Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're asking, why does the K-3 marriage visa even exist? People will often contact me and, the colloquial term oftentimes, especially for people who do their own research on the internet regarding U.S. immigration, the colloquial term for a marriage visa seems to be the K-3, when in reality, the standard marriage visa based on the I-130 form is the CR1 or the IR1, the immediate relative category. But then when people talk to me, they ask me, well, there's this K-3 category. What is it? Well, one, it's a non-immigrant visa. So it's similar to the K-1 visa insofar as it does not confer green card status at entry. And then people ask me, well, what's the point of this? It was actually invented under the Clinton administration pursuant to the Life Act, wherein it was decided at that time, it took like 4 to 6 months to process a fiancé visa, but the backlog on immigrant spousal visas was like 3 or 4 years in some cases. I even talked to practitioners who were practicing at that time who told me they would advise people to get divorced, apply for a fiancé visa, and remarry stateside. It was actually faster to do that. As a result, Congress at the time, probably a pretty good idea, under the Life Act, created the K-3 category, where they basically said, look, we're going to create a non-immigrant visa for folks married to American citizens, and we'll process it through the same line, if you will, as the K-1, because the K-1's backlog was so low. That processed for a while, and then about 10, 12 years ago, we saw a pretty massive change to the overall process associated with the K-3, wherein they decided to do what was called administrative closure at the National Visa Center. And what are we talking about when we talk about the National Visa Center? Well, National Visa Center acts as a kind of a clearinghouse between Department of Homeland Security and Department of State. And when they intake cases from petitions processed by the Department of Homeland Security, they forward them on to relevant embassies or consulates. What started happening was the process of getting the underlying I-130, the underlying marriage visa petition, began to speed up. And we finally saw a situation where sometimes it would even move faster than the K-3, or it would move at roughly the same time. And at that point, National Visa Center decided administratively the K-3 is effectively no longer fit to purpose, and we are going to administratively close those cases where the underlying immigrant petition has been processed. In theory, you could still see a K-3 process these days. As a practical matter, I personally have not seen one processed in quite a number of years. That being said, it does remain an option, and as the Trump administration goes along, I could see scenarios arise where perhaps a K-3 petition, a supplemental petition, might be useful, again, depending on the underlying circumstances in a given case.